We're on.
May I begin? Yes. Good evening, and thank you for being here. This is the City of Glendale Civil Service Commission meeting for November 13, 2014. May I please have a roll call?
Commissioner Yakubian?
Yes.
Commissioner Devine?
Here.
Commissioner Urigi?
Here.
Chair Gazarian?
Here.
For the record, Commissioner Manukian is absent tonight.
Thank you. Next item, please.
Minutes?
Is there a motion?
I move for approval without.
Second. Unanimous. Thank you. Next item, please.
Oral communications?
I have no cards before me. I see no one approaching the podium. Next item, please.
Recruitment and examination report.
Thank you, Mr. Doyle. Good evening.
Good evening. Mr. Chair, members of the Commission, this is the recruitment examination status report. This documents the recruitments for each staff member that have occurred since our last meeting. We have currently 42 ongoing, and again, the report shows the staff assigned, the open, closed filing periods, the dates of the exams, and such. As you know, once an exam is completed, we then establish eligibility list, and that pretty much causes something to fall off this report. So again, this is a note and file item for your information only. If you have questions, be happy to try and answer them.
Any questions? Hearing none. Thank you. Next item, please.
Eligible list established.
Thank you, Mr. Doyle.
Mr. Chair, members of the Commission, this too is a note and file item. This is the eligible lists that have been established since our last meeting. As you can see, we have 5 lists. This time they all happen to be promotional, so you see generally a smaller pool of candidates for these types of exams. But again, we show the total number of applicants received, and in the far right column, the total number of people who made it onto those lists for each of those recruitment processes. So if you have questions on any of these, be happy to try and answer them. If not, again, this is note and file.
I hear no questions. Thank you, Mr. Doyle. Next item, please.
Job bulletin for approval, fire engineer.
Thank you, Mr. Doyle.
Mr. Chair, members of the Commission, this item is a job bulletin for approval for the position of fire engineer. This is a promotional recruitment process that is in the planning stages with the fire department. As sort of a review for all the commissioners, I think you all know that not every job bulletin that gets posted does come before the Commission. There are a few exceptions, and I want to make sure you understand which ones actually do come before the Commission. Typically, if a position was recruited for on a promotional basis in the past and is done on a open, or it's recommended that it be an open recruitment, that's required to come before the Commission. Also, if we have any type of modification to the minimum qualifications or an inconsistency with the approved class specification for a particular bulletin, we would bring those to the Commission for approval. And lastly, any type of recruitment that involves a sworn safety promotional, that would be your police and fire type recruitments, those are all brought before the Commission. This one in particular has to do with a sworn safety promotional exam, as well as there's a slight modification to the one of the many minimum qualifications for this position. And what's being proposed on that end is the modification to not require, there's a specific Smith System driver training course or driver awareness course that is part of the job requirements for this position, and the fire department and staff is recommending that that not be required for this. As I understand, this training is something that we're able to do in-house, and given the timing of when this class is offered and when we need to post this recruitment, that it would not be practical at this time to make that requirement. It could exclude some candidates. So with that, other than that, this is a bulletin that's fully consistent with the class specification. And I do want to call your attention on this recruitment, because this is, in my opinion, one of the most challenging recruitment processes that we actually do. If I could call your attention to the second to the last page of this, which goes through the selection process. you actually see for this exam a written examination in which all the candidates are required to pass each of the components of the written exam, and then once they get past that, there's a 5-part performance practical exam involving pre-check of the apparatus and driving skills, drafting, an aerial ladder truck operation, hydrant exercise, and there's an acting captain exercise as well. The candidates for this position are required to pass each of these components. So, as you might expect, this is quite a challenging process, and the candidates who do make it through, we know full well that they're very well prepared and suitable to be fire engineers for the city of Glendale. So, again, if there's questions you have, be happy to try and answer them. We do have Chief Scoggins here tonight, Battalion Chief Probst, as well as Fire Captain Stavros, who's the president of the Firefighters Association, as well as Manya Hunanian from my staff who worked on this bulletin. So, questions?
Any questions? I don't have any questions. This is the next item.
Oh, wow.
The next item, I have a lot of questions.
I do have one quick question, and I think I know the answer, but we at one time, many years ago, asked about recruiting women and getting women into the fire service. And when I look at this experience, 3 years experience in a municipal firefighting work, of which 1 year has to be in the Glendale Fire Department, that in essence excludes, if I understand correctly, any possibility of a woman being eligible for this, as opposed to if they weren't required to serve in the Glendale Fire Department, possibly someone could come from another fire department that has equivalent experience. So I'm just wondering if you could explain if in fact is what's happening, that there would be no women eligible to take this exam or participate.
Mr. Chair, Commissioner Devine, this is a promotional recruitment to begin with, so there wouldn't be any candidates from the outside. So all the candidates will have worked within our agency for that minimum period of time. You bring up the issue of females. We do have one female who is currently in her probationary phase. We did have another female who retired last year, or I believe the year before that, who had retired at the rank of captain. But as to your question, the one female that we'd have would not have enough time as a firefighter in Glendale or the firefighter in general to be eligible for this.
Thank you.
Any other questions?
Move for approval.
Second? Second. Thank you. Unanimous consent. Thank you. Next item, please.
Report on firefighter disciplinary appeal procedure.
Thank you, Mr. Doyle.
Yes, Mr. Chair, members of the Commission, this is an issue we've been wanting to do for quite some time now. The Commission is well aware of the Public Safety Officer's Procedure Bill of Rights, often called the Peace Officer Bill of Rights, or POBAR. I know many of you have dealt with that issue in several of the hearings that we've had involving police officers and their investigation and discipline. POBAR, of course, provides special protections for sworn police employees in the areas of investigation and the discipline involving sworn police officers. Well, in 2008, the California State Legislature enacted a similar law covering sworn firefighters, now known as the Firefighter Bill of Rights, or FOBAR. FOBAR is very similar to POBAR, but one of the key differences, and this was actually written into the law, is that the disciplinary appeal process must be conducted in conformance with the rules and procedures adopted by the employing agencies that are in accordance with what's known as the Administrative Procedures Act. And specifically, that relates to a section of the Government Code 11500, Part 1 of Division Part 3 of Title 2. Sorry about all the legalese, but that's how this is written. This is the format of hearings that are utilized by the state of California and their departments and the various agencies, and it calls for the hearings that are addressed by the Administrative Procedures Act to be done, presided over by an administrative law judge, an ALJ. That, of course, conflicts with not only the way we do business here, civil service rules and the charter. But there are some other key differences as addressed in the report that require that things be done just a little bit differently. And a couple of those have to do with the final notice that gets served to an employee being disciplined. We call it a final notice of disciplinary action. Under FOBAR, it's referred to as the accusation. The deadline to appeal under our system, we require 5 days to appeal to the Civil Service Commission, whereas the state under the statute has a 15-day deadline. And also the deadline for the ultimate decision to be made by this body are, I won't say our rules, but our policy and procedures for disciplinary hearings call for a decision typically within 30 days of the close of the appeal hearing. Now that's something we don't always reach, but nevertheless that is our goal. Under the state system, under the statute, it's 100 days. But really the biggest difference that we'd have has to do with how the hearings are actually conducted, and this whole notion of having an administrative law judge made part of that. So our concept here is that we want to have a process that both complies with the Glendale City Charter as well as the provisions of state law. And we've done some research on this, both with our own city attorney's office. Miss Maurer did some extensive review, and we've also consulted with some outside counsel, law firm of Liebert Cassidy Whitmore, and we've come up with a proposed procedure which would essentially incorporate the concept of an administrative law judge with the commission as far as both the hearing of the hearings and the conduct of the hearing. And essentially what's being proposed is that the hearing be conducted by the commission, and that the commission go in fact and make the determination, but that the hearing would be presided over by an administrative law judge, and that the administrative law judge sort of take the place as our outside legal counsel, who we utilize and and assist in the ruling on objections and the admission of evidence and things like that. Again, we're quite confident that this process would meet both the state law as well as meet the tenets of our charter and our civil service system. We want to introduce this to the commission tonight, and I know it's probably a lot of information to go through. I want to obviously get your input and feedback and certainly answer your questions, but I do want to emphasize this is not something that we are putting forth because we want to in any way diminish the commission's responsibility or anything like that. We're trying to comply with the tenets of FOBAR and make sure we strike the appropriate balance in making sure that that there is no diminishment of the role of the commission. Yet on the other hand, we want to make sure that we're complying with what the state law requires. So again, our objective is to change as little as possible about this process. And we've had some discussions with our Firefighters Association, and while they're very, very comfortable with having cases heard before the commission, obviously we need to and strike that appropriate balance in making sure that we're meeting the tenets of FOBAR as well. So with that, I'm sure you have many questions, and again, Chief Scoggins is here, as well as Captain Stavros, and Ms. Maurer is here as well. She's the one who did most of the research on how this can be applied to our organization. So if you have questions, either Ms. Maurer or myself should be able to answer them.
Okay. Questions? Go ahead.
Well, first of all, it's kind of a moot point, because in my 8 years on this commission, we've never had a case from the fire department. So I think that speaks well for our chief and our fire people. So anyway, we'll go ahead and look at this.
They're a very well-behaved bunch.
Yes, they are. Anyway.
And well-trained.
Right.
So.
Anyway, what I wanted to ask, just some basic questions from a non-attorney perspective. And word that I'm concerned about is the ALJ shall preside at the hearing. And I'm not sure what that means in terms of this document. When I read further on it, it sounds like he will be acting just as you described, Mr. Doyle, that he'll advise us on admission of evidence and things like that, the way our outside attorney does. But when I see the word preside, I'm not sure if that means that he will actually run the hearing, that he'll have a voice in the deliberations, he'll have a voice in the decision, or whether he'll just be there to guide us during deliberations and during the decision. And in the past, it's always been the chair of the panel that runs the hearing, that presides. And so I'd like to find out, how the ALJ will fit into that scenario.
Mr. Chair, Commissioner Devine, my opinion would be that he or she would be there to guide the commission, and in presiding, my opinion would be that instead of appointing a chair of the commission, that this individual would center and really be the chair of that particular hearing. As far as the decision, our research determined that we believe that decision would be with the commission, and the commission would do their typical vote and bring forth the determination, and subject to writ, and of course, but that would be our.
Also, again, this document refers to the commission, and in our rules, we're allowed to have a panel, with at least 2 or 3 members of the commission. And I'm wondering, under this process, would we be required to have the full commission sit in on these hearings, or can we do it our normal way and the chair can appoint 1 or 2 commissioners to serve on it?
Commissioner Devine, that shouldn't change any of that. I think the provision of the rules that enable the chairman of the commission to appoint individuals, nothing of that would change. You could either, and this is the case now, you could either have the full commission hear it, a subset of the commission hear it, or an individual, any individual that the commission chair decides to appoint. And that person could be the administrative law judge if that were the case.
Well, another option we had was to appoint a outside hearing officer. Let's say we choose to go that route. Would the ALJ then be required to sit with that hearing officer and preside over that particular process?
Commissioner Devine, yes. That would be our belief, that there would need to be some involvement by an ALJ in this process.
And I have one last question before I turn it over to the attorneys that can work on this. Will this change, if we adopt this as written, require any change to the charter?
Commissioner Devine, I don't believe so. And again, I'm at the disadvantage, same as disadvantage you. I'm not an attorney, and maybe Ms. Maurer can address that. But we have sought both opinion from this attorney's office as well as outside counsel as to, trying to identify a procedure that would meet both with the intent of FOBAR as well as what our current practice is under the city charter, and we don't believe that we would have to amend the charter in order to put forth a process such as this.
Thank you. That's all I have.
Okay. Ms. Bauer, may I inquire? How are you?
Good, thank you.
I've reviewed the draft. Am I correct in concluding that you authored the draft per Mr. Doyle's representation?
Yes, I did. We had some assistance from Liebert Cassidy, and they had initially done a draft, and then I took that and modified it. Okay.
I essentially do not disagree with the draft. What I have concerns or questions about, perhaps, are the draft being, is the concept of the draft being all-inclusive of a firefighter's Bill of Rights. Because in my reading of the government code, 11,500 and going forward until such time that it no longer deals with firefighters. I have come across quite a few provisions that the draft does not address. And I want to be specific about my concerns, and perhaps you can put my concerns at ease, or most worst or alternative scenario would be that the draft would be a bit more inclusive, which I think you would agree with. I don't think that you or your office would have any issues, because the government code does indeed control this subject matter with respect to firefighters' Bill of Rights. Now, when I talk about what is and is not included in the draft, 11,507.6, I did not see it included in the draft procedures for firefighter disciplinary appeals. That code section specifically deals with time frame within 30 days after service or within 15 days after additional pleadings are filed. A discovery means whereby a respondent, which I would believe to be a firefighter, would have the right to obtain witness information, name, address, to the extent known to the other party, which would be the appointing agency authority, I would think, but including but not limited to those intended to be called to testify at the hearing. So that would mean maybe there's 6 witnesses, but only 2 are intended to be testifying, could be called to testify, but the other 4 ought to be made known to the respondent. Statements of persons other than the respondent, which claim the act or the omission that is the basis for this disciplinary matter. Statements of witnesses who have personal knowledge of any events that are the basis of the proceedings. Writings, reports of mental, physical, and or blood examinations if relevant. Things which the party then proposed to offer in evidence. That is the gist of 11.507.6 that I would like to see either referenced by number. You don't have to obviously regurgitate all of the verbiage, or more extensively. 11.507.7 is a motion to compel, essentially, if a party has not complied with these discovery obligations. I would like to see that be part of the draft procedures. I would also kindly suggest that 11.508, whereas it is referenced very briefly in the draft, on page 2 of the draft, top of the page is item number 3. A hearing shall be conducted at a time and place to be determined by the Civil Service Commission. That code section gives some flexibility. It gives flexibility as to the place to be selected that is closer to the location where the transaction occurred. For future generation of civil service commissioners and senior city attorneys or firefighters, I don't want somebody to look at the 11.508 and say, well, this can only be in Sacramento, Oakland, Los Angeles, or San Diego, which is clearly not what the code section speaks of. It speaks of that as 4 basic, headquarters for ALJs to be presiding over proceedings, but it also goes and talks about, most importantly, the respondent moving for a change of location or a change of venue, if you will. I'd like to see that covered. Now, 11,511.5, I did not see any reference to it in the draft. And essentially, that code section, for my fellow commissioners, especially my colleague, Commissioner Devine, To me, it represented why the Civil Service Commission should indeed be involved. So when we talk about an ALJ presiding over the proceedings, much like what Mr. Doyle correctly alluded to the fact that that would be essentially an ALJ sitting in as though it is a specially assigned counsel for the commission, ruling on objections and whatnot, as has been the case in our POBAR-driven matters. 11.511.5 actually is a lot more than that, because that code section speaks of, on a motion by a party, providing for a pre-hearing conference, providing for exploration of settlement possibilities, preparation of stipulations, clarification of issues, and a whole host of similar, very worthwhile proceedings that, because the Civil Service Commission is the agency that will be ultimately held accountable or appealed if one party or another is not satisfied with the decision, I would suggest that the proceedings, in fact, take place just like the government code authorizes. And what I mean by the government code authorizing, I now refer to 11.512, which is in your draft. 11.512 has two parts, A and B. The A part says every hearing in a contested case shall be presided over by an administrative law judge, period. The agency, by the way, Commissioner Devine, in my reading and review towards preparing for this evening's hearing, I have come to conclude that when they say agency, they really mean the Civil Service Commission. They don't mean the appointing authority, the fire department, or anybody else. They just mean the commission, the agency. The agency itself shall determine whether the administrative law judge is to hear the case alone or whether the agency, Civil Service Commission, is to hear the case with the administrative law judge. I would request, suggest, and ask that your offices consider having a procedure in place which is authorized by statute by subsection B of 11.512 when it says, when the agency itself hears the case, the administrative law judge shall preside at the hearing, rule on the admission and exclusion of evidence, and advise the agency on matters of law. That actually is covered in your draft, page 1, Roman numeral 2, subsection capital A, subsection 2. And there you have that, and you're actually referring to 11.512B in the draft. That is the preferred procedure for me, because the alternative would be an ALJ judge would hear it, would come, we would be reinventing the wheel, whereas if from the outset, just like we've had it with POBAR-driven matters, I believe that a commission chair, whoever it is sitting on this seat, in this seat, will assign hearing officers, ALJ will preside, and that way, if there's settlement possibilities and everything else, the ultimate body that is held accountable at the very end is in the process all throughout, so that there is no finger pointing down the line, there is no dereliction of duty by anyone, because everybody is on notice as to the issues, as to the possibilities, as to the probabilities. The only other thing that I have to say is there is a reference in the memo from Mr. Doyle to the members of the Civil Service Commission. And that reference specifically is on page 2, top of the page, when it talks about hearing officers' city rules. When it talks about city rules, at least during my tenure here serving on this body, I don't recall we ever approving that an authorized representative has the authority to fully hear and determine matters involving removal, suspension, or reduction in rank or grade of any employee for cause. Now, I do remember that a matter was brought to our attention that was later on deferred, so that sometime in the future we may readdress it, because there was a 2007 or 8 or 9 memo that had authorized a hearing officer that I believe was perhaps from the city attorney's office that would sit and make decisions as to certain disciplinary or transfer or whatnot. But my preference would be that when we do a draft and we make a final set of rules and procedures that apply to firefighters' Bill of Rights, I would be much more comfortable if we do not reference or make part of the record any city rules that are in effect or questionably were in effect or weren't in effect or aren't in effect now, and I believe are supposed to be brought before this body at some point in the future. Because I believe the government code stands on its own merits. We don't need to say, well, this is how we do it with POBAR, so we should do it with FOBAR the same way. The government code really does set forth a very straightforward path. Ms. Maurer, to the extent that you have put the draft together, it's accurate as it can be. I just would like it to be a little bit more descriptive, or at least by reference incorporate those code sections that I spoke of. And I think I have covered everything. Thank you. If you have anything, yes, you may.
Just briefly, Mr. Chair, members of the Commission, I'm happy to add those provisions, and I think what I was doing as I was drafting it is thinking, why are we not just attaching the entire government code? I'm rewriting the government code.
It is, yeah.
So I think that's, at some point I decided some of the things, like the discovery, was more behind the scenes of the Commission, so I thought those are things we'll follow, but it didn't necessarily need to be in the hearing procedure rules.
Right.
But I hear what you're saying, and I don't think there's any problem with adding those provisions. With regard to the 11-512 and the Commission hearing the matter, not letting the ALJ hear it alone, that is something that we met and conferred with the firefighters over, and they were in agreement that it would be pursuant to B with the Commission, and then the ALJ hearing the ruling on the exhibits and the objections and things like that. So that's why I left out A entirely, because everyone was in agreement that that was the way it should be.
Because had you not, then I would. You would be forcing me to open a can of worms and say, what do you mean? The government code doesn't take that away from us.
We wanted to avoid that can of worms, so they did agree with that in advance. And the only other thing is with regard to the comment you just made about the memo, I believe that language about the authorized representative is in Rule 10.
Yes.
That's where it came from the Civil Service rules.
Yes, Rule 10, Section, I believe it's Section 8A, page 37. And it essentially says, upon receiving an appeal which complies with foregoing rules, the Commission shall, within 2 weeks of the filing of the appeal, 1, determine whether the matter will be heard before the entire Commission, a portion thereof, or before its authorized representative.
Then I think, see.
It's never been done that I'm aware of.
At least while I've been here, it hasn't been done. But I know that something was brought where someone was challenging whether what was done was sufficient or was not sufficient, that it should have been brought to civil service. But that matter became moot at some point. But yet the issue, which was a subject of a special meeting, remained, and we deferred it. And I'm not interested in bringing up the issue now. It's neither agendized nor relevant for this discussion. But it kind of, I have to go back and look at the civil service rules, because I haven't looked at civil service rule 10.
Mr. Chair, I think what you may be referring to, and perhaps Commissioner Devine can refresh some memories, there was a proposal having to do with the issue of when something less than the full Commission hears a case, does it need to necessarily come back to the full commission. Let's say we have a 3-member panel.
No, I
or
understand.
even
That's not what I'm
1-member
referring
panel.
to.
It is not?
No, I'm referring to something that went somewhere outside of this commission, and it was decided upon, and then somebody returned sometime later saying, nope, I should have had
I
a
think
day
that
in court
had-
here. A
I
day
think
in the
that had
commission.
something to do with transfer of police officers.
Yes,
And
Yes,
where they developed a process, a procedure.
Right.
Did not include the commission in those
Right.
deliberations.
Right.
And it came back and it was in violation of the charter, the way they had.
Oh, you're
And I'm not-
talking,
right.
I'm not sure where that is now. That's a good point.
I'm not
And I
sure
can
where that
answer
is.
that
I just don't
question.
want to refer to things that are possibly suspect. I don't know that they are suspect. Because I remember I wanted feedback as to that, but the issue that as it related to someone that was making it an issue became moot. So I didn't go back and say, hey, come back and talk about it. But to the extent, and I don't think these references are going to be in our firefighters' procedural rights, correct? We're not going to have references about how we do something else with some other department of some other specialty, sworn peace officer or otherwise.
No, this is just to point out the differences between our
Right.
rules and the state law.
Okay.
And Mr. Chair, your recollection is correct. We are going to prepare the direction of the commission was to bring back another report that outlined the various options, and we do intend to do that in the near future.
Okay, all right. Then I'm glad I haven't lost my mind yet. All right. Thank you very much, Ms. Maurer. I have no further questions. Any other questions from anyone?
Well,
So will it be, yes?
yeah, there was a question pending about the charter. I think
Oh, was
Commissioner
that a
Devine
violation of the
asked
charter?
about that.
What was that you
I
asked?
can answer that question if you like.
Yes.
Mr. Chair, members of the commission, it would not be a violation of the charter because the charter requires that this commission make the final determination, and as the rules are being proposed, that would still be the case.
It still would be the case. We would be still on the hook in the final analysis. So I want to know from Mr. Doyle and Ms. Maurer, does it come back as a final draft for us with more of a wider four corners than this? Then we can then
Yes.
vote on it at that point?
Mr. Chair, the item before you, it's consideration of this draft, and I assumed that there would be much discussion, questions, so I was not going to presume that you were going to be ready to approve of it tonight. So we'd be happy to bring this back at our next meeting pursuant to the changes or whatever recommendations. There is a meet and confer element of this with our Firefighters Association that needs to be addressed prior to a final decision being made. Thus far, the draft that's being put forth, we have met and conferred over that, and thus far they're satisfied with that. However, any changes, we would certainly want to consult with the association.
Well, you'll realize that what the changes are not really changes I'm proposing. I'm just proposing that which the government code speaks of, not Garo's code, government code. So I don't see that there will be any issues with the meet and confer. But Mr. Doyle, did you have a question?
Mr. Doyle?
Divine.
Commissioner Doyle. Commissioner Devine. I've been doing this the last 6 months. It's the D. It's the D. Art. How about Art?
That's even better.
My friend Art. Go ahead.
You actually brought up a question in my mind as you were talking, Commissioner Kazarian. I didn't see anything in here, and I know we have nothing spelled out in our normal or our past rules about timeframes. The only thing that was mentioned here was that within 100 days instead of 30 days, I believe, after the close of the hearing, a decision has to be rendered. And I'm wondering if any thought was given, and I know that there's been a lot of controversy brought up about the time it takes to complete a hearing, from the time the appeal is filed till we select a panel, till we select dates for hearings, cancellation of hearings, et cetera. And you're familiar with those, Ms. Moore,
Yes.
I'm sure. And I know that that's been a lot of controversy. So I'm wondering, in your deliberations, you're conferring with the union and whatnot, whether that issue has come up and whether it might be wise to include in this some sort of rough time frame from the time the appeal is filed until the decision is made that has to be completed with the next amount of time, and put some constraints on there so a hearing doesn't drag on for 4 or 5 or 6 or 8 months. So my question is, was that considered, and or would that be something that you feel could be or should be considered?
I think we would be very happy to consider it. It's not something that we talked about at all. with the firefighters. And like you indicated, there's been so few hearings involving the firefighters that it's really the police matters that I think are the ones that are more of a concern. But I would be happy to address that with them if that is the direction, and to see if we could get them to agree to something where there were time limits, because I think that benefits everyone.
I'm satisfied with the government code. There's a lot more in the government code than I'm opting to speak of publicly right now because it's there, and I know you've looked at it. And as to the concept that we've had issues, or we may have had issues, or we're likely to have issues with the police department matters, I actually disagree. I think I don't expect to see another police department matter here for as long as I'm still here. I'm confident of that. So.
You just jinxed it, I'm sure.
No, I did not. I did not. I think there's a very good environment. Maybe it's the times have changed. I don't know, but I'm very happy with the police department, and I don't anticipate any cases coming here in the frequency that they used to come, at least the last couple of years.
Well, I think what I hear you saying is there's no need to put any time constraints or...
I don't see the need at this time. I don't see it beyond what the government code specifies right now.
I don't know what the government code specifies in that area, but I'll leave that to your expertise. Withdraw my suggestion.
Okay.
Do we need a motion for the next draft?
I'd ask that the matter be brought back. I believe it's in our packet as one of the options that we can utilize, and I'd ask that that my colleagues agree with me that we request to bring the item back at an upcoming meeting, and hopefully that will be after a meet and confer with a little bit more of a wider four corners that you will present to the interested parties, and then it'll come back for us for a final yay.
Okay.
Chair, I have
No motions necessary.
No motions necessary.
just one suggestion. To the extent it's efficient and precise, incorporating by reference may be the best way to go here. Consider that.
Maybe I'll add in the provisions that Commissioner Gazarian mentioned, and then indicate, though, that the entire section is incorporated by reference.
Yes.
So there'll
That
be...
might work. Yep.
Okay.
Yeah, that's a wonderful suggestion. Very well.
Thank you.
We're good? Thank you, Ms. Maurer.
Thank you.
Thank you. Next item, please.
The City Attorney supplement to the report on the interpretation and application of Civil Service Rule 6, Section 2F, pertaining to transfers in lieu of layoffs and on appointments of eligible employees from layoff lists, dated October 8, 2014.
Thank you. Mr. Doyle. Is this Mr. Doyle item, or is this somebody else?
Ms. Varpetian.
Oh, Ms. Varpetian.
Yes, Mr. Chair, members of the Commission, I understand I was not present at the last meeting, and I understand there were some questions that arose relative to Rule 11, Section 2F, relating to transfer in lieu of layoff, specifically with regard to the section having to do with what is an appropriate position that an employee may be transferred to in lieu of a layoff, whether that meant a similar transfer or whether that meant to any appropriate position, be it higher or similar. We've provided a report on that, basically outlining the canons under which we interpret statutory language, mostly relying on the plain meaning of the statutory language. And then we've provided some recommendations in the back. We believe that the rule is clear as it is presented. It talks about it talks about a transfer to an appropriate position, and that's defined as something that's suited for some purpose or situation, especially suitable or compatible, something that's fitting. And we believe that that provides adequate clarification as to what the word appropriate means. Our recommendation is that because the rule is clear, that no change should be made to the rule itself, but perhaps in light of the in light of in reading the totality of the other rules, whether or not the process that's employed by the Director of Human Resources during the time of layoff should maybe be expanded to provide employees who are subject to the transfer with some additional options. And so to the extent that that's a procedure change that's being recommended to the Director of Human Resources, and he was amenable to that based on his representations at the last meeting, no further action is necessary. However, if the Commission wishes to provide further clarification, then we've also provided some options as to how you can do that. We can answer questions.
Okay, questions? I have always questions, but I'm going to defer to you.
I'd like to make two suggestions. Number one, when we heard this last time, Commissioner Haregi had not had a chance to look into it. We never did hear from him in terms of his thoughts on this. And secondly, since this was originally initiated by Mr. Wiedeker, who was here in the audience, I would like to get, before we have any discussion on this, get his input on it, to whether, the suggestions made by or recommendations made by the city attorney are within the scope of what he was thinking about to resolve this issue.
Well, I'm happy to hear from Mr. Whitaker, but I don't know about resolving an issue because at first we have to, before I hear from Mr. Whitaker, I would like to know if we have questions as to this memo from Ms. Varbetian, because once I have Mr. Whitaker come up, I am certain Mr. Whitaker will have a great deal of insight, and it may or may not be consistent with Ms. Varbetian's memo. I want to know first if I'm satisfied with the recommendations of Ms. Varbetian, or if we have questions about it, because I have a question about it, at the very minimum. And then, of course, I'll hear from Mr. Whitaker, and then we'll see where we go. Do you have questions from Ms. Varbetian? What are you looking at?
I mean, I'm a little bit confused as to the recommendations that are made, because on the one hand, it seems like you're saying that the city attorney is not recommending any changes, but then on the other hand, you're saying that the definitions have to be amended, which is a change, so I'm not really sure.
Mr. Chair, members of the Commission, we do not believe that the rules require an amendment, but there was extensive discussion at the last meeting whether or not the way that the rules were written would be cause for confusion in the future. And if the Commission's inclined to expand on those to provide further clarification, you may certainly do that. We don't recommend that you do that, but if you are inclined to go in that direction, we thought it was in the interest of time we would present those options to you, and I think we've provided 3 different options. Our recommendation isn't that you make those changes, but rather than bringing it back to you at a future meeting with possible amendments, we thought we would put that in the memo now.
Let me just say this. Since we're talking about options or recommendations, I can tell you categorically that option 1 is not acceptable to this commissioner. It is not acceptable to this commissioner because it is suggestive of defining a transfer to mean laterally, intra or interdepartmentally or divisionally, or between classes possessing similar qualifications. So far, I am tolerating that until I get to, or moving from one class to a lower classification. I have a problem with that. Because the minute I have in a definition of a transfer moving from one class to a lower classification, that to me then makes each and every transfer to a lower classification appropriate.
Yeah.
Mr. Chair, I can address that. That particular section, that definition, is what's currently there. The only proposed amendment is what's underlined. And that specific section is actually highlighted in the charter, and that is in subsection 9 of Article 24, Section 2. Mm-hmm. And I reviewed that section because it was amended in 1949. That particular section was added by way of a voter amendment, so it was up for a vote Regretfully, we were unable to find the city attorney impartial analysis, any arguments for or against. We can only tell you that as that section appears in the charter presently, that's what the voters approved in 1949. And that specifically states for transfer from one position to a similar position or to a lower position upon request of the employee affected, et cetera. And the balance is not related to transfers.
So then you're saying that only the last line, which is underlined, is what is a suggested additional interpretation for the word transfer.
And that's also true for option 1, option 2, and option 3.
The underlined portions are...
Correct. That's the red line version, so that if you're inclined
I see.
to go the route of making further clarification, then we're proposing those 3 options. You're obviously free to make other changes. But we go back to saying that we believe that the rule is clear on its face.
But I'm sorry, then explain to me in your memo on the face sheet of it, the first page, you have cited Rule 11, Section 2F, correct?
Yes.
And you have, in citing Section 2F, you've identified Section F, transfer in lieu of layoff. The city manager may order the permanent or temporary transfer of any employee to any appropriate position as determined by the Director of Human Resources in order to avoid the layoff of employees. You see, I took that any appropriate position as an appropriate position. Now appropriate position may be a lower classification, but it doesn't have to be a lower classification, correct?
Yes, and the way you're reading that is consistent with the conclusions in the memo.
It is consistent.
It is consistent.
Right. So if it is consistent, let me get back to my option 1, which I did not like because it seems to further echo something that I don't want it to be in black and white, lower or to a lower classification. It may be a lower classification, I understand. The second option, frankly, I don't understand it. I don't understand it that when we're saying, as determined by the Director of Human Resources in order to avoid the layoff of employees, I think that every employee has the right to be laid off. If, obviously there is no involuntary servitude last time I checked. So we're not going to force people to take a position. They should have the right to say, no, I don't want to be transferred. If the only option then left is to be laid off, they should have that opportunity to say, fine, go ahead, lay me off.
And Chair Devine, that too is consistent with the conclusions of the memorandum. And what we're proposing is part of the recommendation is not to adopt that proposed amendment, but instead suggest to the Director of Human Resources that as part of that layoff notification that they lay out the options of, you have the option to be laid off, you have the option to be transferred, or you have the option to be terminated, and then permit the employee to make the selection. It's implicit that they have the right to make that determination. Our office's recommendation was that the HR director, in fact, memorialized that in the notice letter to the employee. So what you're describing is also consistent with the recommendation in the memo.
I like option 3, transfer in lieu of layoff as set forth in Rule 11, Section 2F. Now, having said that, I will tell you this. Since you have, I believe you had mentioned somewhere in your memo that you went and consulted with the dictionary as to definition, Webster, defining what's appropriate. I must tell you, I consulted Google, my dear friend, as to the definition of what's suitable, because you've used the word suitable in page 2. You have said here, are you enjoying yourself, Mr. Doyle? There you go. And my fellow commissioner, here the rule provides an alternative to the employee being laid off or being bumped to an even lower classification. It confers a benefit to an employee by expanding his options from either a layoff or a bump to a much lower classification to any position where he may be suitable as determined by the Director of Human Resources. My friend, with respect to suitable, Mr. Google says, or Ms. Google, what is right or appropriate for a particular purpose, a person. What is right or appropriate for a particular person, purpose, or situation. Synonyms: acceptable, satisfactory, fitting. Informally known as right up someone's alley. So, if it's right up someone's alley, that's suitable. If it's appropriate, that's suitable. If it's all of the above, it's suitable. But it's determined by Director of Human Resources, and I could tell you, as a trial lawyer, judges have a great deal of discretion, and if they abuse their discretion, we take them up on appeal on abuse of discretion. I don't see how we can change what's already on dried ink on a piece of paper. It seems to be sufficient. Now, I would like to hear from Mr. Whitaker as to where what I believe the rules to be sufficient have run afoul as it relates to Mr. Whitaker, because that's my missing link if it's run afoul. Any other comments? Mr. Whitaker, please come up. Yes, you are excused.
Mike Whitaker. I believe you've heard quite enough from Mr. Whitaker, and I'm surprised that you would desire any more. So thank you for your courtesy to me. And for your courtesy at the last meeting. We went on quite a long time. I'm going to try not to talk out of both sides of my mouth, but I probably will be unsuccessful and will do that. So I'm going to apologize right up front. I can only offer my own opinion, and that would be the support that no language change in the rule is necessary, but that the procedural change that is recommended makes a great deal of sense. Now, this is from my bias. Mr. Jaregui was kind enough to ask some questions at the conclusion of last month's meeting that provided a lot of clarity. And that was my contention, was that the charter and the rules provided for lateral transfers unless initiated by the employee. This completely solves that by saying that, in fact, transfers are lateral. The employee is informed you're being laid off, and you have the choice, if there's a position to bump to be laid off and be unemployed, or, as I read their line, the employee is then allowed to request, and because the employee is doing the requesting, then the lower transfers are well within our rules. So that would be my talking out of both sides of my mouth. This would still maintain the authority of the director to identify the positions that would be appropriate, but it would maintain and protect the employee's right to not be involuntarily transferred downward without initiating it. So I think you've already heard too much from me, but that would be my take on it.
Very well, thank you. Ms. Arbethian, what do you make of Mr. Whitaker's
I heard Mr. Whitaker to say that he too agrees with our recommendation.
Except I'm just not quite understanding your recommendation.
Our recommendation is to...
So you gave me three options and I lost you there.
Well, actually, there are four options.
Four options.
The first option is to do nothing.
Okay.
For our recommendation.
Okay.
But if the commission is inclined to go in a different direction, then you have three mechanisms by which you may amend the rules, and yet maybe the fifth option is for you to make a proposal of your own. I perhaps should have notated that in the memo, but I didn't. Sorry.
Yeah, I would state it. Sorry. Are you finished? I would say it a little differently. There are four recommendations, and the first recommendation involves no change to any definitions, any terms, any provisions, correct?
That's correct.
But it recommends in the implementation at the time of layoff that certain procedures would be followed In my view, these procedures are extremely practical. They clarify this, they provide clarity to the situation, and they ensure that the employee or subject is fully aware of their rights.
And I will say, Commissioner Haregi, that process has been more or less implicit in the current practice. We have had employees subject to layoff who have been given alternatives under this provision of the rules, indicate we're not interested, lay me off, or I'll bump back to this position instead. But I agree with what you're saying. We can make it more explicit in the process and in writing, in fact, if that's
yeah, it does. It makes this would make it clear for those who don't understand that it's implicit in the process that they have this right still.
Yes.
With that, I would move to action number 1, to note and file a report with the condition that the Director of Human Resources be directed to follow the procedure set forth in the City Attorney's recommendation as far as notification of the employees.
If I may ask clarification, to move per the recommendation, which is to provide in writing, essentially, what is articulated in the first paragraph right under the word recommendation.
Correct.
Above the options.
Yes.
That I would, yes, I would agree with that.
We need a second.
Second.
Okay. Unanimous. Thank you. Thank you very much. Next item, please. Thank you, Mr. Whitaker.
Thank you, Mr. Whitaker.
Is there any other item?
Civil Service Commission, staff comments?
Comments? I want to offer my condolences to our fellow Commissioner Sam Manoukian's entire family. When we received notice today of a reminder of our Civil Service Commission meeting, we also received, unfortunately, the response from Commissioner Manoukian, a hardworking, dedicated civil servant and a citizen of the city, that informed us that his mother had passed away. And our hearts go out to Sam and his entire family, and I ask everyone that knows Sam to reach out to him in his time of grief. Thank you. Any other items do we have?
Motion to adjourn?
Move we adjourn.
Yes, adjourn. Thank you.
Thank you.